The Retirement Cafe podcast, Statutory Wills and What Happens When You Die Intestate, or If You Die Intestate, with Holly Mieville-Hawkins. Hello and welcome to another episode of the Retirement Cafe podcast with me, your host, Justin King. If you're thinking about your retirement or already retired, you're in the right place. My aim is to help you plan for and live a successful and meaningful retirement. Retirement is far more than just a financial event. It's a significant life event, a major transition, which will bring with it new challenges and opportunities. So each episode contains tips, information, and inspiration to help you feel more informed and confident about your retirement. I hope you enjoyed today's episode. Hello and welcome. I'm so glad you've joined me for this week's podcast episode. This week, I am delighted to be joined by Holly Mieville-Hawkins. I met Holly on a webinar run by SOLA, which is the Society of Later Life Advisors, an organisation that I'm a member of. And I met Holly a few months back. I found what she had to say fascinating and thought that her passion and experience for looking out for vulnerable people was inspiring. Holly is a solicitor who specialises in the Court of Protection and mental capacity. She has spent her career making and defending applications in the Court of Protection to make sure people's wishes are carried out once they no longer have capacity. Holly is passionate about helping to shape the legal arena of mental capacity law and actively works to achieve this. She sits on the Wills and Equity Committee at the Law Society, which consults to the government on issues around mental capacity and lasting powers of attorney. She's an active commentator also in the national media. I've recorded 2 podcasts with Holly. This one focuses on what happens when you die without a will, known as dying intestate, and the role of statutory wills. Our second conversation focuses on gifting as part of your legacy planning. Check out the show notes to find out more. In this conversation, Holly and I discuss what happens if you don't have a power of attorney or if the implementation of your power of attorney goes wrong, mental capacity and the Court of Protection, and what happens when you die or if you die without a will. I hope you enjoy my conversation with Holly as much as I did. Welcome to the Retirement Cafe podcast, Holly Mieville-Hawkins.
Thank you. Thank you very much, Justin. It's absolutely fabulous to be here. I'm really excited to be invited and to be sort of joining you. So thank you.
Well, I've been looking forward to this, Holly, for ages. But for those people who don't know of you, can you tell us a little bit about who you are and what you do?
Of course, yeah. Well, so I'm Holly Mieville-Hawkins. I am the head of the mental capacity group at Michelmores, who are a sort of Devon and Cornwall and Bristol-based law firm. My job day to day is I advise attorneys and deputies, who are people that represent people that lack mental capacity to make their own decisions. I sort of advise them in their decision making day to day on behalf of those people that lack mental capacity. So day to day, I'll be advising people on gifting, on making wills, on sort of estate planning, on care home fees, that sort of side of things. And I also sometimes get involved where things go a bit wrong, where there might be an attorney or a deputy that's done something a bit naughty and might need removing. So that's my job.
Wow. Okay. So already we're going deep into this. So straight away, obviously you're a lawyer and your speciality is dealing with people with mental capacity, as you mentioned, and Court of Protection and all this type of thing. So, you know, we've covered on the podcast before things like how important it is to get a power of attorney in place. But obviously sometimes that hasn't been done, and sometimes also it kind of goes wrong. And this is really what you're getting involved in.
Yeah, absolutely. So, I mean, I'm sure you've covered this before on your podcast, but there's a difference between something called an attorney and something called a deputy. So if you have capacity to make decisions about who you want to help you with your finances or your welfare decisions, when you lose that capacity, you can make something called a lasting power of attorney. And a lot of people are doing that. I think I spoke to Nick Goodwin, who's the public guardian, last month, And he said at the moment they're having 30,000 applications a week, I think. So it's a huge amount of applications for lasting powers of attorney are being made at the moment. And it's been a big glut following the COVID lockdown. If you don't do that, so you don't get round to it, or maybe there's a problem with the attorney that you've appointed because maybe they're ill or they've lost their own capacity or they've died or something like that, then all is not lost. Don't worry, you can do something called the Court of Protection can step in and they can appoint a deputy for you, and a deputy has got all of the powers that an attorney has. So basically their job is to manage your money, sell property, buy property, manage your pensions, make investments. They can do inheritance tax planning to a certain extent, and that's something I know we're going to talk about a little bit later. And they sort of do all of the things that you could do with your money, both an attorney and a deputy can, and they'll be sort of monitored by a government body called the Office of the Public Guardian, just to make sure they're not doing anything too naughty with your funds. So that's the difference between the two.
Sure. So let's just take a walk through maybe you'll give us some real life stories, but I'm just imagining, we live in Christchurch and we have a big retired community, an elderly community, and of course, but you could lose capacity at a young age. I mean, you could have a car accident or what have you, or we had a client who is suffering dementia and lost capacity at the age of 54, so it can hit you at all types of ages. But let's say sadly someone hasn't put a power of attorney in place, and all of a sudden is losing capacity. What point does I don't know, maybe the social services step in, or what point do you guys step in, or how does it unfold? Or let's say I was a concerned neighbour and I'm worried about Fred, my next door neighbour, and I'm thinking, he's not acting exactly like he used to do. I'm a bit worried about him. How does this all unfold?
The thing to remember is that mental capacity isn't an on and off switch. Say the way that Mental Capacity Act is drafted, it was drafted in 2005, so it's quite in the world of law, quite a recent piece of legislation. And actually it's a very modern and very practical piece of legislation. It says that mental capacity is time and question specific, and whilst that sounds a little bit legally, what it means is that you can have capacity to make some decisions. So you could maybe have capacity, maybe Fred has still got capacity to decide where he wants to live, to give a £10 gift to his granddaughter for Christmas. And he may even still have capacity to make a decision about who he wants to represent him when he gets a little bit worse. And that would have capacity to make a lasting power of attorney. But it might be that Fred's got to the point where actually he couldn't manage decisions about changing his pension, or making offshore investments, or selling a property. It might be that those sort of issues, because they're a little bit more complicated, they're larger sums of money, they're more complex transactions, sort of weighing up the sale and sort of offers and insurance, that sort of thing, that might be a little bit beyond him. So the thing to really focus on is that mental capacity is issue specific, but it's also time specific. And what that means is that a person might have capacity in the morning, but not in the afternoon. I know for a fact the mornings are my time. I am bright, I'm bubbly, I'm on top of things in the mornings. If you ask me the same question at about 3 o'clock in the afternoon, particularly if I haven't had any chocolate or something, I'm waning. Basically, I'm not quite as bright at that sort of time of day. By about 5, no point in talking to me. So and mental capacity, the Mental Capacity Act recognises this. A lot of people are better at different times of day. Some people are complete night owls, and actually, there'd be a duty to engage with that person at the time that works for them. So basically, mental capacity, not on and off switch. So if you've got a situation where someone's starting to lose capacity, the first thing to do is to try and get them to make a lasting power of attorney if they've got that capacity. And within the lasting power of attorney documentation is something called a certificate provider. And a certificate provider is a person that will assess their capacity to make a lasting power of attorney there and then. So, if a person will only be able to make a lasting power of attorney if they've got the capacity to do so, basically. So that's the sort of first thing to do. And what I would do is always recommend that someone goes to see someone called Solicitors for the Elderly if they're going to get a solicitor. And that's an organisation that's a sister organisation to the organisation that Justin's a part of. So Justin's part of something called SOLA, Society of Later Life Advisors, and that's the financial advisor arm of Solicitors for the Elderly. So it's basically a very specialist, very dedicated, very passionate solicitor that really cares about elderly issues, who will really understand the issues surrounding making lasting power of attorney and capacity, and will really be able to sort of set that person on the right track. And so if the person's sort of starting to lose their capacity, they've probably still got capacity to make decisions about where they want to be living. So it's probably quite a good moment to have that chat with them, maybe write their views down so that they can be taken into account at a future time where you're making best interest decisions, which is where you lose capacity to make a decision. Other people will have to make that decision in your best interest, but they'll have to take your views into account. So any sort of written wishes and feelings, either within the lasting power of attorney document, or even just a letter to Dear Social Services, these are my views, this is what I'm concerned about, I would like to stay in my house as long as possible, or I would like to go into this particular care home, this is where my will is found, that sort of side of things. Just write things down, help the person to express their views in a way that is got a long lasting sort of element to them. So writing them down is always a really good idea.
So Holly, I come along to see you with Fred, and because Fred's told me he wants to sell his bungalow. Mm-hmm. And you have a chat with Fred and you think, I'm not sure he's got the capacity to do this.
Yeah.
Where do we go from there?
I would immediately assess his capacity to make a lasting power of attorney, because it's much easier than making a deputyship order. Sure. So a lasting power of attorney is much cheaper, much quicker. Normally, well, at the moment, the waiting list is about 15 weeks for registration of lasting power of attorney with the Public Guardian's Office. Right. But normally it's about 8 to 9 weeks. They've just got a glut at the moment because of the COVID lockdown measures ending and people just getting their powers of attorney done.
Sure. And so let's just, in this instance, you assess the capacity and you go, do you know what, Justin, Fred, really, I don't believe he's got the capacity. We're too late. We've missed the boat, right?
That's fine. You make an application.
What happens next?
Make an application for the appointment of a deputy. Now, you can download these forms yourself online on the gov.uk website, and they're quite complicated forms. They can feel a little bit intimidating, but the information they're asking for isn't rocket science. So you just have to sit down and sort of go through the person's finances with them and sort of fill in as much information as you can with the person if they've got the capacity to do so. Name, address, date of birth, that sort of thing. What their assets are, what their income is, what their outgoings are, and if you've got a deputy in mind who can be a professional, or they can be a friend or a family member, that's all completely fine. You sort of pop that information in the application form as well. £365 for the Court of Protection application fee. Pop it over to the Court of Protection. There's a fee remission service available as well if you haven't got that money, or the person hasn't got that money. That's absolutely fine. The application form is really easy to find on the gov.uk website. And then the frustration then is it takes about 6 to 8 months to get a deputy appointed. Wow. It's and that's on a good day. It can take 8-9 months just for a really non-contentious deputyship order to be made. And that's why I'm such an advocate of lasting powers of attorney, because during that period of time, no one's got the ability to manage that person's finances, that you're basically in a frozen state. So,
now,
sorry
for interrupting, Holly. Is there any, I can imagine, me applying to be a deputy as a lay person, not in my professional kind of remit at all. And in fact, it's not something that I would entertain as a professional remit, especially if it was a client, so there would be a massive conflict of interest, I think. Yeah. But is there, so let's say I went along as a lay person, because my friendly neighbor, Fred, needs some help, and we've got to apply for me to be his deputy. Does the court look more favourably on someone like yourself in speed wise rather than some kind of lay person? Because I can just imagine that you guys are you can put your hand in the air and say, like, I'm a trained professional, I know what I'm doing. You rubber stamp this. I'm Holly. You know who I am.
They don't actually. There's an agreed order of preference at the court, and the court would actually prefer a friend or a family member to do it, because they think that they will know the person better. And I can see a lot of merit in that argument. So there's no difference in speed whatsoever. I think that there's a difference in monitoring after appointment, and there's a difference in cost of the insurance. So basically a deputy's always got to have an insurance policy. It's called a bond. And so if it's a lay person, it's the appointed deputy, they'll have a higher monitoring basically than a professional, and they'll have a more expensive insurance policy, because the chances of them running off with the money are slightly higher than a professional, I suppose. And also a professional's got indemnity insurance as well. So you're sort of double insured if you have a professional acting for you, but there's no difference in speed. The only exception to that is if you have someone called a panel deputy being appointed, and that's basically there are deputies of last resort. So if there's no one available whatsoever, the government have got a list of sort of approved professionals. And if they are being appointed, that can sometimes be a little bit quicker if there's a sort of really urgent need for them to be appointed. But as a general rule, it's sort of a 6 to 8 month thing.
Wow. So it's good. It's great that we've got this system in place, and that a deputy can be appointed. But 6 to 8 months is not going to help many people if they need to do a transaction, is it?
No, not at all. And the thing is with a deputy is that they used to have more powers than they do now. So the way of viewing deputyship is that the courts are sort of bestowing the decision-making rights onto the deputy. Now, they used to give quite a lot of rights. So they used to automatically just say, it's fine, you can sell their house, you can make X gifts, you can make whatever investments you like, subject to getting a financial advice from a qualified financial advisor. The court have sort of changed the way they make orders in this last few years, and they've sort of restricted somewhat the powers a deputy has on a day-to-day basis. So every deputy order is slightly different, but more often than not, you'll find that a deputy won't have authority to sell a house or buy a house without specifically going back to the court and asking for that. And it's a blanket rule that a deputy doesn't have the authority to make a will for a person, and it's a blanket rule that an attorney doesn't have the authority to make a will for a person. So there were quite a lot of restrictions on both attorneys and deputies that those attorneys and deputies will have to be aware of and work within. And making a will is one of those absolute no's. You can't make a will on behalf of someone that you act for, essentially, without a lot of additional authority.
And of course, this is yet again another document that we see is kind of often forgotten or not completed. I was only sitting with some clients yesterday afternoon who are particularly successful and affluent, and the last 3 years I've spoken to you about wills and powers of attorney. How are we doing on those? We will sort
Familiar.
it out. We are going to sort it out. Would you like me to arrange that? Yes, please. Right. Okay. Right, let's really crack on. And I often explain to people, I said, it's a bit crackers that obviously without the power of attorney document, is that, I'm talking to you as a couple at the moment about your individual savings and investment plans, but actually if one of you loses capacity, I won't be able to talk to the other one about the other one's plans. It's
without that power of authority,
without that authority.
Yeah.
So I know it seems daft that we're sitting here talking about them jointly today, but if you come in next week and Bill's had a stroke, we're in trouble.
I just did a slip of the tongue, actually, and I called them a power of authority, but I think that actually might be the best way of looking at them. They are powers of authority, and without them there is no leeway to speak to you about your husband or wife's interests at all. So they're really crucial.
Kind of one of those things, isn't it, that you feel that you should be able to, I use my husband's bank card, or my wife uses, you can't actually.
No, unless it's a joint account, obviously, and that's slightly different. But even with a joint account, where one person loses capacity, often you'll find the bank will freeze the account. So you've got to be really careful. I just can't stress enough the importance of making a power of attorney to make your life easier as it goes on.
So sadly, we've got my friendly neighbour Bill, who's lost his capacity, and you've kindly stepped in and said, right, I've got to apply to the court to be a deputy. But we also now find that he hasn't got a will. Where do we go from here?
So when you don't have a will, the intestacy rules apply, and that sounds again like one of those weird legal words, but what that means is it's basically a set of rules that apply to every single person in the country if they don't have a will. And I'm not going to go through all of the intestacy provisions now, because that would be ludicrous and very boring for everybody. But basically, it's a set thing. So just as an example, if you are married and you have no children, all of your money will go to your spouse. But if you've got children, then the rules change slightly. If you don't have children, you don't have a spouse, then it goes to other people. So it's basically a set of rules, and it'll keep going down the sort of list until you sort of get to like second cousins and that sort of side of things. And then if you don't even have them, then actually it will all go to the Crown. So if you want to have any decision making about. And actually, to be fair, intestacy is right for some people. Actually, some people do just want it to go. They're widowed and they want all their money to split between their children. They don't want to have a particular choice of executor who's the person that manages your estate for you. They don't want to make any charity gifts. They don't want to set up any trusts. They're sort of willing to take the chance, I guess. That might be right for some people. But it should always be a considered decision rather than just like a default. Actually, I can't be bothered to make a will. Let's go for intestacy. If you've got anything that you want to have that's in any way, shape or form a bespoke or slightly complicated, or you've got children, you want to appoint guardians for them or anything like that, you should definitely always have a will. And the tests for I remember I mentioned earlier that the mental capacity is time and issue specific. The test of capacity for making a will is actually lower than the test of capacity for managing finances, which sounds a bit strange. So it might be that your neighbour has capacity still to make a will, but doesn't have capacity to manage his overall finances. Now, one of the things I love in life is just how old cases can still be really, really relevant in law. And the test for mental capacity is set out in a case called Banks and Goodfellow, which is from 1870. That is still the law now. And that was confirmed in a case earlier this year in the High Court. Someone brought it to the court and challenged it and said, this can't possibly still be the law. And the judge went, it's still the law. So the test for Banks and Goodfellow in 1870 said, in order to make a will, you need to understand the nature and effect of making a will. You need to understand broadly what your assets are. You don't have to say, I've got £93,000 in this HSBC account and I've got a property valued £364,000 in Bath or whatever. You can just sort of broadly know you've got quite significant savings, a property, etc. You need to know who your beneficiaries are, and importantly, and this is one where people often slip up, what obligations you've got towards those beneficiaries. And so you might have a situation where and so in the Banks and Goodfellow case, the chap who was the sort of subject of it was suffering from insane delusions. Basically, he believed that he was frequently visited by devils and evil spirits. But because those insane delusions didn't impact his decision making in terms of his will, he actually was found to have mental capacity to make a will because he understood the nature and effect of making a will. He understood the extent of his assets. He knew who his beneficiaries were and what obligations he had towards them. His insane delusions as a result of like being visited by devils and evil spirits were in respect of other things in his life. So he actually, despite the fact that he had quite significant mental capacity issues about other areas of his life, was found to have capacity to make a will. Now, I often find with people where I'm talking to them about capacity to make a will, it's that sort of last sort of strand, who the beneficiaries are and the obligations towards them, that can be quite difficult for a person to manage. And because people will have confusions in their relationships, or they become forgetful about that some people with dementia sort of regress to a sort of previous states. They won't necessarily remember who all of their children are, or that they'll become obsessed or fixated with an argument that happened 20 years ago or something like that. So that often will be the thing that trips people up. And so if you don't pass that test of mental capacity set out in Banks and Goodfellow in 1870, you will have to have something called a statutory will made for you. And that sounds, again, really scary, very complicated, but actually it's just literally a will, but with a slightly different top and tail to it, that is made on your behalf by somebody that the court authorises to make it for you. So it's quite a long court process making a statutory will. It can take about a year.
So, Holly, can I just step back a second? So,
sorry,
you
went down the legal route.
No problem at all. This is great, and thoroughly interesting. So, but in essence, Fred, my neighbour, is going to die intestate. He hasn't got a will. So, can't we just rely on those rules of intestacy? Why do we want to go down the rules of a statutory will?
It all depends on the person's situation. Like, a lot of people in this country die intestate. And as I said, it can be the right thing for people. Like, if they've just got one daughter that should get it all, and they want that daughter to administer their estate when they're dead, and they haven't got complicated assets, and that everything's in the UK, it can all be absolutely fine. But if you want to give a gift to a friend or a charity, set up a trust, you've got a disabled child, you want to give different proportions and just equal, you want to maybe give like one daughter 10%, another daughter 20%, or you want to do anything that goes away from that very, very basic intestacy provisions, then then and you also don't want to take a risk that things might change after you've made the decision to do intestate, because you might make a decision that intestate suits you now, but things might change once you've lost your capacity. Like your daughter might predecease you, and then you need to be able to sort of not control things, because you can't control everything, but you need to sort of make provisions. So I'd always recommend a will is put in place, just because it gives peace of mind. But
so the statutory will really would be, this is obviously where someone has lost the capacity to make a will. Yeah. So and therefore they've probably at this point have appointed either they've got an attorney or a deputy.
Yeah. Yeah.
So we know that's happened because it pretty much, from what I hear you saying, if you haven't got the capacity to make a will, you haven't got probably the capacity to make financial decisions either. Because
it's the other way around.
The test for a will was less than
So if you haven't got capacity to manage your finances, then you might have capacity to make a will. But if you don't have capacity to make a will, then you won't have capacity to manage your finances. But they are finely tuned.
That's what I intended to mean if I got it, or if I got it back to front. But so at this point, in essence, the attorney is coming along and maybe coming and having a conversation with you and saying, right, it looks like we need to make a will for Fred. Can you how do we go about creating a statutory will?
So the government have got some really good guidance on this. So the process is a little bit complicated, and it is probably one of those situations I would recommend you get a solicitor involved in, because my personal view is that a badly drafted statutory will application can cause a lot more cost and a lot more delay than a well-drafted one. So actually, whilst you do have to pay for a solicitor, it would nearly always be the capable person's money that would be used to pay for the solicitor. But that solicitor will put together sort of like a very streamlined and good application, and hopefully sort of cause less delay and problems further down the line. So you can go to the government, that they've got all of the forms. If you sort of just Google statutory will, court of protection, the forms will come up for you. So you've got the COP 1. Normally you put a COP 1A in, which is this sort of where you put your assets and that sort of thing in it. COP 1C, which is sort of saying sort of who you are, why you're making this application. You do a COP 24, which is a witness statement, and that's the key to making a statutory will application, because to that witness statement you'll sort of attach the proposed statutory will, so the will you want to make. Things like life expectancy, a capacity assessment, what impact this will have on inheritance tax that will be payable, because obviously inheritance tax is quite an important consideration when you're making a will. Why this will, and this is importantly, is in the best, this proposed will is in the best interests of P, who's the person that lacks mental capacity. And so you attach all of these things to your witness statement, and you normally do a COP 3 as well, which is the sort of formal capacity of assessment. And you send all, and the Court of Protection have sort of produced what's known as a practice direction, which sounds again really, really lawy, but actually the practice direction is really, really helpful, because actually it just literally lists all the things you need to attach. It's really, really good. It's got a bullet point list of all of the things you need to put into the application. And if you put all of those things into the application, you pay a £365 fee, actually it will go to the court. The court will then look at the application, and it will ensure that you've told everybody, and this is the really key bit, you've got to tell everybody that's currently a beneficiary, i.e. someone that would benefit from the person's money if they died, or is proposed to be a beneficiary. So they've got to see a full copy of the application paperwork. And then the Court of Protection will appoint an independent person to represent the incapable person. Now, that independent person is normally called the official solicitor, which again sounds a bit weird, but they are the government body that represent people that lack mental capacity to manage their own finances, because the Court of Protection are quite worried that an attorney, who's often a daughter or a son or a friend or a deputy, may sort of have a slight conflict of interest, because they might want the will to all go to them. Whereas actually the Court of Protection will say, look, we need someone independent to represent the person that lacks capacity here. They'll appoint the official solicitor to represent the person. And all the beneficiaries have got the right to have a say as well, but normally they don't, unless there's sort of like big family conflict or something like that. And then it normally takes somewhere about 6 to 8 months, maybe 9 months, and all of the parties will sort of have a chat about, what people's views are, whether this is the right thing for the person, and then if they think that it is, then it will just get approved with an order and sort of a stamp, and it will come back to you, and then you can sign the will, and send it back to the court, and then they stamp the will and send it back to you, and then it's all done. But sometimes it does become slightly contested and there might be a need for a hearing. But the basic rule about costs is that all of the money would come from the person's estate who lacks capacity. So normally they would sort of pay for everything, but then if there's a party that's behaving really unreasonably, like there's a daughter that says, no, absolutely not, all of the money should always come to me, dad always wanted to give me 100% of his money, you're all outrageous, how dare you even say that it should be 50-50 or a charity should get some of it, that person's quite unlikely to get all of their legal costs paid by dad, because they're just being so unreasonable that it doesn't seem very fair. So that's the statutory will in the nuts and bolts of it. But yeah, there we are.
Brilliant.
And you can't make one as an attorney or a deputy without going through that process. You have to go through that process. There's no option. Making a will, just getting someone to sign it, it's not going to work.
So I've just got a couple more questions on that, Holly. Just that, who's the executor in that scenario?
Whoever you ask to be the executor. So there is no set executor. So an executor is the person that administers the estate. And so a statutory will is literally just a will, just with a different signing clause and a different starting clause. So it can cover everything, like funeral wishes. It's just exactly like a normal will. So it can cover whatever. And
therefore, I think you probably just answered my second question, which was, can these wills be challenged under the normal course of wills that we hear about?
They can, but it would be very unlikely.
Beneficiaries, I'm a son and I wasn't in the will, so I want to make a claim. You
can, but it would be really unlikely because, as I said a minute ago, everyone that might be a beneficiary, sort of who would be his beneficiary under the current will or the proposed will, gets named as a party, basically. So they've got the right at that point of making the statutory will to have that argument. So you don't really get two bites of the cherry. Yes, whilst they could then challenge it after death, the High Court, when they're getting the application for challenging after death, will say, well, you've had your chance to have a say about this. Why didn't you say this 2 years ago? I'm sorry, we've had this argument. I'm not interested in hearing this anymore. But there might be a situation where there's like a long lost son who wasn't involved in the statutory will process. And of course, obviously, if they're like someone that should be a dependent and should have been provided for and they accidentally got missed off, then yes, there would be an argument in theory, but it would be very difficult to challenge a statutory will after death.
Great. Well, that's absolutely fascinating. And I know that I've got tons more questions about lots of other topics, but we're going to have to save those for another podcast episode. So, Holly, I'm so glad I got you this morning rather than this afternoon. When
3 o'clock, not a good idea.
When who knows what would have happened.
Well, I've got a meeting with my boss at 3, so I really feel sorry for him.
So I look forward to chatting with you again on the next episode.
Thank you.
But thank you for your time today, Holly.
Grateful. Thank you.
Thanks once again to Holly for joining me today. To find out more about statutory wills or to get in touch with Holly, check out the show notes on our website at theretirementcafe.co.uk, where you'll find some useful links. If you want to subscribe to catch the next episode with Holly, please do so and click the red button below for the video and subscribe, and you'll be notified when there's a new one coming out. I would also like to take a moment to thank Jackie Cleveland, who wrote a 5-star review on Apple Podcasts following my interview with her a few months ago. She said Justin is clearly intent on helping retirees live a great life. Episode after episode, he and his guests share information and services that can make a real difference to retirees. Well worth listening to and highly recommended. You can find my conversation with Jackie in episode 126. If you've enjoyed this episode, please do leave us a review on Apple Podcasts, as it really does help others like you find us. And did you know that all the podcasts are available to listen to or watch on my YouTube channel? If you prefer to watch my conversation, simply head to YouTube and search for Justin King MFP. If you'd like to get in touch, you can find me on Twitter at JustinKingCFP, or you can also email me at hello@theretirementcafe.co.uk. So until next time, I'm Justin King, helping you feel more informed in your retirement.